Can you please state your name, whom you represent, and your position on the bill?
Hi, my name is Leigh De La Reza. I'm a board-certified family law attorney. I'm here on my own behalf and also on behalf of the Texas Family Law Foundation. I have a lot of experience.
Are you testifying for, against, or on the bill?
I'm testifying against the bill. I have a lot of experience in family law cases. I'm board-certified. It's all that I do. I've been in practice for about 16 years. I've had cases that I've taken to trial. I understand what it's like to actually go to court and plead fault and try to win a case based on fault. This law is going to require both parties to agree to a no-fault divorce. So in 1969, our legislator enacted the Family Code, and it became effective in 1970. No-fault ground was added to the existing grounds of divorce, and insupportability became a part of our Family Code at that time. There's a famous case called Cusack v. Cusack, and in that case, the court talks about that the legislator's intent was that society is better served by terminating marriages which have ceased to exist in fact. What this bill would do is it would make it so that if one person claimed insupportability, unless the other person said insupportability as well, you would not be able to get divorced. You would have to find some fault ground. It's not easy to prove fault. In order to show that somebody has committed adultery, you have to show that there's actual sexual intercourse. In order to prove abuse, a lot of times abuse happens behind closed doors. Nobody sees what happens. You would have to prove that that happened in order to get divorced. There are other reasons that people get divorced that wouldn't even fall into one of our existing fault grounds. What if somebody is a drug addict? How do you get divorced from that person? What do you do if somebody has left the home and you're doing a default divorce? You don't know, maybe you don't know where the person is. How are you going to claim, how are you going to have the other person have a no fault as well if you're doing a default divorce? One of the biggest problems of this is it's going to create incredible expense for our court systems that are already overtaxed. The family law cases take up a good portion of the court system. Our courts aren't going to be able to handle each case having to prove fault in order to get divorced. Pro se litigants aren't going to be able to go to court and prove fault in a divorce. That's a huge trial. It's more than just putting papers through and making sure that everything is done appropriately. It's a lot. And more people are pro se litigants. They're not going to be able to handle it. We're also seeing more and more people that are just not getting married. Thank you for your time.
Until it turns red, but you're almost done. Okay, the chair recognizes Representative Wu.
Don't leave.
Oh, yes. Sorry.
Did you had, I think you had maybe like 10 seconds left on, you want to finish your thing?
Oh, no. So in closing, I would just say that it's going to clog the court systems. Our courts can't handle it, and it's way too difficult.
You've represented men and women in divorces for a long time, right?
Yes.
Okay. Have you ever represented clients who were in abusive relationships?
Yes, frequently.
Yeah. And would it be fair to say that the abuse is not always physical?
Absolutely. There's oftentimes verbal and emotional abuse, and those cases are very hard to prove.
And like verbal, emotional, psychological abuse may not even qualify as abuse under the Fault Act.
Absolutely.
Okay. And would it be fair to say that the perpetrator of abuse often uses the marriage itself as a form of abuse?
Yes, and sometimes they'll even extend that to the children and start using the children as a way to further abuse the other spouse.
And would it be fair to say that sometimes someone who uses the marriage as the abuse would not want to let their partner go and would use this as a form of continued abuse?
Yeah, they never want to because they're abusing that person. So they don't want to let that person go. They want to continue to abuse them. And they will make a divorce as complicated and as difficult as possible. They will use every resource that they have to take away any kind of financial ability from the other person, and they continue to abuse them as long as they can.
Thank you.
Thank you, members. Any other questions for this witness? Chair recognizes Representative Chair Frank.
Do any other states operate this way? No?
I don't believe so. I know there's other countries. It's been a big problem in England. I know in Taiwan, it's been a problem because I've had clients from those countries. And in those situations, you have to really look, maybe you hire private investigators, you try to record people, you try to do everything that you can. And what happens is if you can't prove any kind of fault, then you're not able to get divorced. That leads to all sorts of further problems. There was a really famous case that's been in the papers from England, and they're trying to change their law there because it's become such an issue. But I'm not aware of any states in the United States that don't allow fault.
When did you say we changed to the no-fault divorce? Did you say 69?
Yeah, the legislator enacted it in 1969, and it became effective in 1970.
Okay, and did the courts all, as you said, the courts couldn't handle it. I guess I'm trying to figure out if in 70, did all of a sudden the courts have a bunch of excess capacity because things became so easy?
Well, you had a big change in society. So divorce has changed over the course from the 1970s until today. Our cities are also a lot larger. I know here in Austin, we are at capacity in our court system. Our cities have grown quite a bit since then. So yeah, there's been a number of changes, both in population and in the way society views marriage.
Yeah, there has.